What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we're going to break down a question so many of you had. Once we found out Brian Freedman, Justin Baldoni's lawyer, and their team went forward with this public website that is going to have a lot of the case info and documents on it. Is that ethical? Are lawyers allowed to do that? Are there exceptions? Are there limitations on what they can actually post on that website? We're going to break all that down in this video. Plus, the judge reportedly commented on this specific issue in the very first initial hearing that they had today, February 3rd. Let's get into it. So this is the website, and it is called thelawsuitinfo.com. And so far, the only two things that are on it, at least right now as I'm looking at it, are the first amended complaint, all 224 pages, and a timeline of relevant events. This has also been filed, as you can see, which is going to be important as we talk through it. A lot of this is the exhibits. A lot of this, a lot of these things are specifically contained in the complaint, but they just wanted to put it in timeline form for everybody to be able to read, and they are available as downloadable PDFs. So we had our first initial hearing today, and it was in federal court, so there are no cameras. So we're going to have to be relying on some reports throughout this, at least the civil employment case in California. And according to most of the reports, the clients were not there, the lawyers were there, and the judge was very, very hesitant to issue a gag order. But instead, some of the reports were they were going to implement Rule 3.6 of the ethical rules for lawyers. You don't have to implement that. You don't have to say that's in play. It's always in play. It's in play every day of our lives as lawyers. And if we violate the ethical rules or the rules of professional responsibility, we can get in trouble for that. We can get sanctioned. We can lose our bar license. There are all sorts of negative effects that can come if we violate the ethical rules that we all know that we are under. And they mentioned 3.6 and implementing 3.6 and 3.6 being applied. We looked at what that rule 3.6 was in California and in New York in another video. If you want to see the deep dives on those, go ahead and check out our prior video on the Lively Baldoni playlist. But for the purposes of this video, we're going to take a quick look at some of the relevant sections of the ABA, the American Bar Association, which it's Rule 3.6 here as well. We'll take a look at the top, trial, publicity, and comment. And we're going to look at some of the paragraphs and some of the comments here of this rule to give us an indication as to what it means that this is going to be implemented at this point and how it affects the website. Does it mean he has to take the website down? Is he going to have to be careful what he puts on that website? We're going to read through this rule and another rule that's incredibly important for lawyers if they are going to publish anything like this in a case publicly for the world to see. The ABA is the American Bar Association. Most jurisdictions will use at least part of this language or start here as they craft it specifically for their state. And I'm going to read this for a specific reason as well when we talk about what Baldoni and his team can and can't do with this public website, depending on what the judge in the California case specifically says. So paragraph 3, the rules set forth a basic general prohibition, meaning you're not allowed to, against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. Recognizing that the public value of informed commentary is great, and the likelihood of prejudice to a proceeding by the commentary of a lawyer who is not involved in the proceeding is small, the rule applies only to lawyers who are or who have been involved in the investigation or litigation of a case and their associates, meaning not me, not Peter Tragos, the lawyer you know, a real lawyer, barred lawyer, who is not the lawyer on this case, right? We're specifically thinking for Baldoni's team and lawyer dealing with this website and, of course, Lively's lawyers when they're making public comments. That's who these rules specifically apply to when you're talking about publicity of trials of cases like this. Paragraph 4 says, paragraph B identifies specific matters about which a lawyer's statements would not ordinarily be considered to present a substantial likelihood of material prejudice and should not in any event be considered prohibited by the general prohibition of paragraph A. Paragraph B is not intended to be an exhaustive list of the subjects upon which a lawyer may make a statement, but statements on other matters may be subject to paragraph A. And that's where they talk about public records, anything that's part of the public record that's been filed in the case. Those are things you're allowed to talk about. Those are things you're allowed to publicly post. And as we look at the lawsuitinfo.com website, the amended complaint is filed. It's public record. The timeline of events, I believe that's also public record at this point, have been filed, but almost everything except maybe the narration in the middle was part of the amended complaint and is an exhibit to the amended complaint. So far, most, if not all, of the information on the lawsuit info website is public record. So it won't be considered what there is a prohibition against. There are, on the other hand, certain subjects that are more likely than not to have a materially prejudicial effect on a proceeding, particularly when they refer to a civil matter triable to a jury, a criminal matter, or any other proceeding that could result in incarceration. Any relevant factor in determining prejudice is the nature of the proceeding involved. Criminal jury trials will be the most sensitive to extrajudicial speech. And that's important, and I want to point that out. Criminal jury trials will be most sensitive to extrajudicial speech. Civil trials may be less sensitive. And we have the benefit of knowing how the judge initially, at least from reports, was looking at this. They are not gung-ho about a gag order. They don't want to shut everybody up. They're not shutting down the website. At least we haven't heard that they have made the decision that you have to shut down that website. This is a civil jury trial. They are less sensitive than criminal jury trials. Less rights involved, less liberty at stake. And it's important that we don't conflate the issue or make improper comparisons between a lot of the criminal cases we're following and a civil case. Non-jury hearings and arbitration proceedings may be even less affected. And that's obvious, right? If you're going to be in front of an arbiter or just in front of a judge, almost, I'm not going to say who cares publicly, but you're not going to poison a jury pool. You're not going to affect future potential jurors if there are no jurors and the judge is going to be making this decision. The rule will still place limitations on prejudicial comments in these cases, but the likelihood of prejudice may be different depending on the type of the proceeding. And that's important. And the judge is going to do that analysis thinking this is a civil case, not a criminal case. Finally, extrajudicial statements that might otherwise raise a question under the rule may be permissible when they are made in response to statements made publicly by another party. And that's what Baldoni's team is really standing behind. Another party's lawyer or third person where a reasonable lawyer would believe a public response is required in order to avoid prejudice to the lawyer's client. When prejudicial statements have been publicly made by others, responsive statements may have the salutary effect of lessening any resulting adverse impact on the adjudicated proceeding. Such responsive statements should be limited to contain only such information as is necessary to mitigate undue prejudice created by the statements made by others. So while Baldoni and his team have focused on they're already responding to allegations that are prejudicial that Lively and her team are putting out there, they've done that, right? And now that the judge is hammering 3.6, 3.6, 3.6, make sure you're ethical and you're only saying what is absolutely necessary to basically defend your client publicly. If you've already done that, maybe you don't need to do it as much. And here was Mr. Freedman, Justin Baldoni's lawyer, after the hearing. Let's hear how short and sweet he is and what we think he's going to do in the future.
I think, and that's Brian Freedman right there in the tan jacket. If we can go live, let's take it.
And we really respect Judge Lyman, and we're really looking forward to moving the case along as quickly as possible. Our clients are devastated and want to move the case along as quickly as possible. And we just couldn't be more pleased with how the case was handled today, how it was managed. And we're going to move as quickly as we possibly can and prove our innocence in a world where sometimes people judge you before they give you a chance. And we're going to change that. Thank you.
So that's it. Short and sweet. I think he's going to keep it that way. I think he's responded as necessary and will continue to do so, but he wants to prove their innocence. Yes, it's a civil case, but don't get them wrong. They want to prove they are innocent. Okay, let's get back to it now. A very big rule, a very important rule in high profile cases that lawyers always need to pay attention to, of course, and you guys are going to know about this as well, is be very careful what information you reveal about what your client tells you. All these lawyers are very experienced, so I don't expect this to be an issue, but I thought we have to bring it up because when you're talking about publicly disseminating information, either in interviews or on a website, which is very unusual. I don't remember this ever happening. Maybe you guys can let me know in the comments. I don't remember a lawyer specifically. Now, if it was his PR team or Baldoni himself putting something under, they're not necessarily under the ABA rules, right? Then a judge would have to issue a gag order or instruct a party or their agents not to do something. But when a lawyer is behind it, and Freedman has said, we are going to put this stuff out there publicly. We want people to know. And frankly, it's a pretty genius move because it makes it look like you've got nothing to hide. You're the ones that want to be transparent. And speaking of transparency, people seem to believe that when there is public interest, that it should be more blockage, right? Everybody's so interested in it. Let's not let them see it. But when there's more public interest, that's a reason for more transparency. That is a factor to be weighed. And whether or not you're going to issue a gag order or seal documents is the public interest. All right, let's talk about it. A client-lawyer relationship. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. The point is the client needs to consent to whatever it is that you are going to post publicly or say publicly about their case. And we can assume that because this amended lawsuit has been filed, the client consented to what is in there. And it is so pro his client. And a lot of it is his client's own text messages that he screenshotted, they got from his phone. I would think and I would hope everything that gets posted on this website is specifically cleared through Justin Baldoni so we don't run into any client consent problems. And it should be done before it's posted, not after. Let's talk about a couple other limitations and things these lawyers need to be concerned with and think about as they go forward. If they're just going to continue to publish things that get filed in the docket or are part of public record, they need to obviously be careful and make sure they don't file anything that's been sealed, because they will have a copy of it. It might look like it's in the docket on their computer or how they're looking at it, or it's in their system as a filing. You know, we have our system where we have everything that's been filed in the docket. We have a download of that document. So hopefully they're not just downloading it there and downloading on this website. I don't think they are, but any sealed documents, if the court determines they should be sealed, if you post them, that's a big problem. If there are any redactions made to any documents, you better make sure those same redactions are shown and redacted, I should say redacted, not shown, on your website where you're posting these documents publicly. You better make sure you're not posting them unredacted, or again, even if it's a mistake, even if you completely didn't mean to do it and it's completely harmless, but then a judge looks at it and says, this is exactly why we can't have this. This is a problem, take it down. And frankly, federal judges are more likely to shut something down or really put their foot down more than state courts, which leads me to a point I wanted to talk about as well. We're going to come back to other things they have to worry about with the website. But let's remember, even if this California federal court judge in the employment law case filed by Blake Lively puts a gag order out, says you can't put anything out publicly about this case. Well, how does that apply to state court in New York? How does it apply to the New York Times case that Justin Baldoni filed? Those documents are also public. State court is usually, obviously, more transparent than federal court, as we've seen with cameras and things of that nature. But sometimes state court judges want to follow suit with federal court judges. So if a federal court judge issues a gag order, is that going to make a state court judge more likely to? Well, I don't know. We'll see. But theoretically, they would have a pretty good argument saying, Judge, we're posting stuff that's in the New York Times case. We're posting our complaint that we filed. This is a complaint she filed against us. We're not going to file our answer. And frankly, this document is their amended complaint. Let's pull it back up here. So if we're taking a look at what's on the lawsuit info, this is a United States District Court of the Southern District of New York. This is not a California case. So if the California judge issues a gag order, interesting concept. Does this, which deals with almost the same exact things and is responding to the allegations she put in her California employment law complaint, would the judge think this is covered under the gag order? That could be an interesting aspect to this case as well. Which orders and which judges are really going to control this case? Then the other two limitations that you really have to be careful about are if you misrepresent any facts, right? When you put a timeline out, that's fine. But if you publicly misrepresent facts, that's going to be an issue. If you reveal any confidential information, even if it wasn't redacted and should have been, and later you found out it should have been, but you have now publicly disseminated this, that could be a problem as well. So maybe you redact the documents you put up there, even if they're not public record, or even if they're not redacted in the public record. You have to be extra cautious yourself if you're going to create a public website like this. And the last thing I would say, right, this is just kind of my thought, is I would put a disclaimer up. I would put some kind of disclaimer that either the documents on this website are all public record, or the documents on this website are all consented to by my client. The documents on this website are not put out here to convince any potential jurors anybody's right or anybody's wrong. It's just about transparency. It's just about the facts. We just want you guys to be able to see the exhibits too. Some kind of disclaimer like that might be a good idea on this website that you have to click yes to before it even takes you into the documents. Now, I'm sure they don't want to create roadblocks or speed bumps for you to get to this information or to get to these documents. Just in an abundance of caution, that's probably something I would do as well. People are going to click through that disclaimer. Hopefully they read it, but they're going to click there to get to this website. That's not really something that would make me think is going to lessen the traffic to this website. So that's one thing I would add as well, is potentially a disclaimer. So in summary, in my opinion, it is ethically appropriate for Baldoni and his team to post public documents and things that the client consents to the lawyers posting on this website for the public to review, as long as there's not a gag order in place. It doesn't look like it violates anything in Rule 3.6. And as long as there's client consent, it doesn't look like it's violating anything in Rule 1.6. So at this point, it looks like it's okay. And the judge chose to not issue a gag order today, knowing this website exists, which makes me think at this point, the website is staying up. Let me know what you think. You think that's fair? You think it's not fair? You think it's ethical, just as a layperson or a lawyer out there watching? Is it something you would do on your case? Is it something you would want your attorney doing on your case? Please let me know in the comment section, and make sure you guys like this video. For now, that's all we got.